Thank you, everybody, for joining us today to talk about funding your trust and making sure that all your assets are properly in your trust. My name is Mark Krause. I'm an associate attorney in the estate planning department with Kopenbarger. I'll be talking through how to fund your trust today with you. I should say we've got a nice little legal caveat in the beginning, just as a CYA for us. So I should tell you that this is for educational purposes only, and that this is not intended to be specific legal, accounting, or tax advice. We obviously have to put that in there as attorneys to protect ourselves. Everybody's situation is ultimately very unique, and one size fits all advice is usually going to be inadequate. So what I would say is if you have any questions or anything that can be, about how to move forward, please schedule an appointment with us, and then we can get a full assessment of your specific situation and give you legal advice that's actually specifically tailored to you. Here's a snapshot of all the attorneys. Obviously, Kopenbarger is a little bigger than some of the other firms out there in this space. A lot of times firms tend to be just one attorney or maybe two attorneys. We have a number of attorneys to help you across multiple departments, including estate planning. We have business and tax attorneys. We have estate administration, and then we have a litigation department as well. This is a picture of all of our great staff that helps us out and makes us look great as attorneys every day. They're very great staff, and it's a pleasure to work with them. As well, I should say we have locations all over California for your convenience, from all the way up in San Jose and Santa Cruz, all the way down to San Diego. So we can meet you where you're at. So the agenda for today, we're going to talk about, first of all, obviously what a trust is. We're going to talk about funding your trust. We're going to get into some specific legal issues related to those topics, and then discuss what belongs in the trust and how to make sure your trust is properly funded. So obviously, the first question is, what is a trust? A trust is essentially a contract you make with yourself so that you can exercise management and control over your assets. It might be kind of funny, but initially, for most people at least, they're going to be both the settlor and the creator of the trust and the trustee. And the reason why we enter into this funny kind of contract, for the most part, amongst other reasons, is to keep your assets in your estate out of probate. So as the name suggests, a living trust is created during your lifetime. And it stays with you while you're alive. It helps you manage and distribute your assets after you pass away. And as I mentioned, it avoids one of the dirtiest words we have in our industry, which is probate. And it makes sure that your wishes are followed as to what happens to your assets, both while you're alive and after you pass. So some different kinds of trusts. Obviously, you might have heard the terminology of a revocable trust versus an irrevocable trust. A revocable trust, as it suggests, can be revoked, meaning it can be revoked at any time. And it also means that while the settlor, the creator of the trust, is alive, changes or amendments can be made at any time. By contrast, an irrevocable trust, as it suggests, cannot be revoked, meaning it's meant to be permanent. Usually, irrevocable trusts are created for certain specialized tax or other sort of higher level planning reasons, potentially sometimes for Medi-Cal or public benefits purposes. They can also be created. There's certain kinds of trusts that you can create irrevocable life insurance trusts or certain kinds of charitable trusts if you have higher level estate planning concerns, due to having a particularly large estate and wanting to deal with certain kinds of tax consequences. We can help you with all those things. If you do have those kind of advanced level concerns about dealing with taxes in a particularly large estate, please schedule an appointment again to talk with us, and we can try to help drill down and come up with the best strategy for you. Unlike it sounds, irrevocable trusts don't 100% mean that no changes can be made. Usually there are things built in. You wouldn't call them amendments, but usually there are things built in that give you certain powers of appointment to at least make certain kinds of changes, usually with regards to who the trustee is and sometimes who the beneficiaries are. Key roles, I've already touched a little bit on these. A settlor or a grantor, those are different names, sometimes also referred to as the trustor. That's the creator of the trust, the person who is going to be entrusting their assets to the trust to be held in the trust. The trustee is the person that exercises management or control over those assets, the person that's in charge of the trust. And of course, the beneficiaries are the person or persons for whom the assets are held in order to benefit. So they're the persons that benefit from the trust initially. Always the settlor or the grantor is the only beneficiary of the trust while they're alive. And then typically, you know, their children or whoever else they might pick will be the beneficiaries after they pass away. And the trustee's job is to always exercise management and control over those assets in accordance with the rules of the trust for the benefit of the beneficiaries. So, how do you fund your trust? What does funding your trust even mean? Well, the most basic thing I could say is that funding your trust means how to put assets in your trust. So another way to say that would be to transfer ownership of assets into the trust. It should note that a trust only protects the assets that are actually held in the trust. So essentially, a trust is a full set of rules that apply to only the property and assets that are held within it. So if you had an unfunded trust, a trust with nothing in it, it would be sort of like writing a full-fledged constitution for a country that had no citizens. Those rules would govern anybody that happened to be in that society, but if there were no actual citizens, it wouldn't be much use. It's the same thing for a trust. It sets all the rules for anything that happens to be in it, but it's a big problem if nothing's in it because then the rules govern nothing. So why funding matters. Number one, usually the main purpose why people prepare a trust in the first place is so that you can avoid probate, which hopefully everybody on here is aware of what probate is. In general, it's a very long, expensive, unpleasant legal process that people have to go through in order to transfer assets and settle accounts for somebody that's passed away if that person didn't do proper estate planning. So if you don't properly fund that trust, though, then the trust isn't going to work to keep you out of probate. If you leave assets out of the name of the trust, then you can find yourself, and many people do find themselves still having to go through at least some degree of the probate process in order to transfer that asset in question. It also allows you to maintain control over your estate because, again, the rules that you set in your trust only apply to assets held in the trust. So you will not be able to control assets to the same degree if those assets happen to not be in the trust. And obviously it ensures that your wishes are honored in terms of how those assets are handled and what happens to them after you pass away. Common mistakes. These are very common mistakes, some of them extremely common mistakes. Obviously, the most basic one, as I've already touched on, forgetting to fund the trust in the first place. Big problem. If you go through the trouble to prepare a trust and then you forget to transfer any assets into the trust, then that trust is going to be pretty much useless, like I've said, and that's a big problem. Another really common problem that people don't consider has to do with refinancing your home. A lot of times, for some reason, what the lenders like to do is to tell you when you're refinancing to do a deed transferring title out of the name of your trust in order for them to effectuate that transaction. And then they tell you, don't worry, you can always transfer title back into the trust once we've completed the transaction. And the problem, as you might be able to guess, is that people forget to transfer title back into the name of the trust afterwards. And if they never pick up on that, and then they later pass away, that property will not be in the trust when they pass away, and therefore the rules of the trust won't apply to it. So that is a big problem that does make attorneys like me quite a bit of money. So it's something that we want to be careful to avoid. Not updating beneficiary designations. So there's certain kinds of assets that I'm going to touch on a little more detail later on that are beneficiary designated. And in order to fund the trust with those kinds of assets, typically what you would want to do is list the trust as a beneficiary, but it's a general problem with any sort of IRAs, 401ks, life insurance policies, HSAs, FSAs, annuities, any of the kinds of assets that you have that could be beneficiary designated. If you want to change your beneficiaries, you need to make sure that the changes are actually reflected with the company and that you've actually updated those beneficiary designations. Because if you don't, then it may go, you may have beneficiaries on there that are no longer with us. You might have beneficiaries on there that you no longer have a very good relationship with. So you do need to make sure that those beneficiary designations are updated. Another problem, taking title as an individual rather as trustee of your trust. So if you buy, say, a new house or open a new bank account, A very common mistake is you will just not think about it and take title as an individual, and then that will mean that whatever the asset is, whether that's a house or a bank account, that asset won't be in the trust. You need to make sure when you're purchasing a new piece of real property, which is, a house or land, or an investment property, or if you're opening a new account, like a bank account, checking account, or a non-beneficiary designated investment account, make sure you should have a document called a certificate of trust, and you should take that to the institution and make sure that you've taken title in the name of your trust. Otherwise, it won't be in the trust. Keeping separate property out of the trust that could have been protected. So one thing people miss sometimes, and we have a special clause in every trust that we do that explicitly covers this fact, but some people think that you can't hold, say if they have a joint marital trust, that you can't hold separate property in that trust. That's not true. You can specifically transfer separate property into that trust without compromising its character as separate property. Simply by transferring separate property into the trust does not by itself, without you taking additional steps, transmute it into community property. So if you have a joint marital trust and you are keeping separate property out of it because you're worried about transmuting it to community property, that's something that you need to discuss with an attorney, because you don't need to do that. And if you keep that separate property out of the trust, there's a very good chance it's going to wind up in probate. Legal implications. So one thing that I really want to highlight that people aren't aware of, it usually doesn't come up, but it is true. If you've ever seen, many old trusts had a provision in it which will say that the trust is initially funded with $1 or $10 or some sort of nominal amount. The reason why they all say that is because the California Probate Code technically stipulates that a trust must be funded at the time it's created in order to be valid, meaning obviously that if it's not funded at the time it's created, if there are no assets in the trust at the time it's created, then it is not valid. A lot of times people take that for granted, but I have been involved in a trial where a judge ultimately, for various reasons, found a trust not valid. And one of the things she cited, because it had that kind of a glib, this trust is being funded with $1, and the other things that were undertaken to fund the trust proved to be invalid for other reasons. And so one of the rulings that the judge had was that the trust itself was invalid because it was not funded at the time of its creation. So that can be a big, big consequence of not properly funding the trust. Obviously, I've already touched on community property versus separate property concerns. The main thing, just again to reiterate, is that simply by transferring community property and or separate property into the trust, it doesn't automatically change the character of that property. And unless you have some sort of separate estate planning vehicle set up for your separate property, you'll want to transfer that separate property into your trust. You'll just probably want to work with an attorney to make sure it's done properly, because otherwise that separate property asset will potentially end up in probate or some sort of other probate adjacent procedure in order to actually transfer it after you pass away. Prop 13 and 19 reassessment rules. So in the past, we had something, we still have it, but known as the parent-to-child exclusion. And that was an exclusion from having a property tax reassessment if the transfer was being made from a parent to a child. And that used to be a pretty broad exemption from having real estate reassessed in terms of the property tax, but that has changed drastically as of 2021. Prop 19 went into effect, and it's greatly restricted the ability to qualify for that exclusion, such that now the only kinds of transactions that qualify are transfers from a parent to child where the parent utilized the property as their primary residence for at least 2 years, and where the child is taking the property as their primary residence. So if the child is taking the property as a rental or as an Airbnb, it's not going to work. If the parent is trying to transfer a rental property that they didn't live in, it's also not going to qualify for the exemption. It's important because there are certain things we can't exactly use a trust to get around it, but in order to help ensure that a child has the option to take advantage of, Prop 19 and the ability to possibly qualify for that exemption from reassessment, one of the things we can build into your trust, if it's, advisable if you want, is a right, what's called a right of first refusal, to help preserve a particular child's opportunity to take the property as their primary residence if they want to qualify for reassessment. So it's very important to to have that property in the trust in order for us to try to build in that possibility and preserve that possibility. Importance of title. Incorrect titling can require probate, as I've touched on. If your house is titled in your name as an individual, or your and your spouse's names as joint tenants, it is not in your trust, and none of the trust rules will govern it. And when you pass, it may get caught up in probate or a probate-like situation. It's important to note that proper documentation protects your estate. So what I mean primarily by that, as the slide suggests, is updated schedules. If you have a trust with us or even with someone else, in back of your trust, if you look at the back of the trust document, there should be documents entitled Schedule A, Schedule B, sometimes Schedule C, Schedule D, and that's going to be a list of all the property that you have. Schedule A should be property titled explicitly in the name of the trust, and usually either Schedule B, if you're a single person, or Schedule D will have beneficiary designated accounts that are a little different. But what's really important is to make sure that those schedules, especially Schedule A, are updated, because even in a situation where, let's say, you've made a mistake, and to circle back to the scenario where you've refinanced and maybe forgot to put the house back in the trust after you completed the refinance, if your property is listed in your schedules in Schedule A, that can help us that can provide your attorney with an argument to try to use a legal procedure in court to make that asset, have a court declare that asset as property of the trust without going through a full probate scenario. So it's very important to make sure that all your assets in your schedules are up to date, because it can demonstrate your intent as to where those assets should be, and that can really be a help to your future successor trustee in trying to make sure all those assets are in the trust. So what belongs in a trust? As I've touched on, number one, real property. For many people, this is what triggers them getting a trust in the first place, is they suddenly find themselves in possession of a house. And once you own a home, it's pretty much a slam dunk that you need a trust. So real property, whether that's your home, your rental, your vacation properties, all of that for sure should be in your trust. Banking and investment accounts. Most of these kinds of accounts follow a title like your home. So your basic checking and savings accounts, the ones that aren't beneficiary designated, you'll want to make sure that they're titled just like your home in your name as trustee of the trust. And that's how we make sure those accounts are in the trust. And you definitely want to keep them in the trust, because if they're not in the trust, again, then when you pass away, the trust rules won't apply to them, number one. And number two, it may require a full probate or some kind of probate adjacent procedure in order to access those things. And I should note that also includes safe deposit boxes. Safe deposit boxes typically follow a title as well. So it's important to check on if you have a safe deposit box. And that's one thing that gets left out of the analysis sometimes. Make sure that those are also properly titled at the bank in the name of your trust. Business interests, if you have an LLC or some other corporate form or legal entity that you have your business in, it's important to try to, one way or another, have this be in the name of the trust too. Typically what we can do is prepare an assignment of interest that essentially transfers that entity into the name of your trust. And you also want to make sure as well that those are updated on your schedules as well. Personal property, tangible items, jewelry, art, collectibles, vehicles, even clothes, all that stuff that you can touch that's in your possession, that's going to typically be tangible personal property. And you're going to want to make sure all that's in the trust. And there's a very simple way that we do that. When we prepare your trust, we prepare one document called an assignment of personal property, and that will make sure that all that property is property of the trust. And it's very important to note, specifically for cars, when we're talking about the DMV, that assignment controls over any contrary titling, including at the DMV. So you do not have to, if you've done your trust with us or if you've done your trust somewhere else and you have that assignment prepared, you do not need to try to title your car in the name of the trust. That can cause various issues that you really don't want to deal with. Sometimes insurance companies will treat it like it's a separate legal entity, like almost like a business or an LLC, rather than treating you as an individual. So it might raise your insurance rates, might cause your insurance to drop you. Another thing people don't think about typically is if you have your car titled in the name of your trust, if you get into a car accident and there's a legal dispute about that accident, that can give the opposing attorney the opportunity to do discovery, and in doing discovery to peer into your trust and your estate planning and get a hold of all those documents if the car is held in the name of the trust. So that's definitely something you want to try to avoid, is actually trying to title your car with the DMV in the name of the trust. So what does not go into your trust? That's the obviously next step after the last slide. Life insurance and retirement accounts. Also, you see further on down, HSAs and FSAs, certain annuities. These are all things that follow beneficiary designations. Technically speaking, most technically, although if you try to retitle these kinds of assets like IRAs, Roth IRAs, 401ks, 403bs, life insurance policies, if you try to go to the company you hold the policy with or the account with and title it in the name of the trust, usually they just tell you no, that they can't do it. Technically, you can transfer title these kinds of assets into the name of the trust, but it's just extremely ill-advisable because it'll cause all kinds of complicated tax issues, and usually it'll defeat the purpose for which you had to open this kind of account in the first place, because usually you're trying to take advantage of certain kinds of tax rules by creating the account, and you'll basically muck it all up if you try to title it in the name of the trust, which is why most companies will just tell you no. So you will not explicitly hold title to these assets in the name of the trust. But if you look, say, at your Schedule B, if you're an individual, or a Schedule D, if you're a married couple, you'll see these kinds of assets listed. What you can do in order to try to fund these assets into your trust is, if your situation makes it a good idea, to list the trust as a beneficiary on those accounts. So those accounts will go wherever the beneficiary designations set out upon your passing. And it can be a good idea in certain situations to make the trust the beneficiary. So usually what I'll say, if there is a good reason to have, if you're a married couple, to have each spouse listed as the first beneficiary and the trust listed as the backup beneficiary. And definitely a scenario where I'm gonna always advise you to list the trust as a beneficiary is, you'll see it says GST/SNT. That's short for generation skipping trust, or a special needs trust, or a supplemental needs trust. Whenever there are subtrusts created under your trust, these kinds of subtrusts are just vehicles in which we make distribution to your beneficiaries rather than distributing their inheritance to them outright. It'll be distributed into, for one reason or another, into a certain kind of trust. Sometimes we call GSTs lifetime trusts or lifetime protective trusts. If those things exist, then the only way that these assets, these beneficiary designated assets, are going to ultimately get into those trusts that you've set up for your beneficiaries is if you funnel them through your revocable living trust as a whole. So you definitely want to make sure, if you have a special needs trust or any kind of GST provisions, that you absolutely have these kinds of accounts with the beneficiary designation list, with the trust listed as a beneficiary. Otherwise, especially in the case of special needs planning, if the money from one of those IRAs or life insurance policies goes to a special needs beneficiary directly, it can greatly mess up the situation with their public benefits. It can subject that money to clawback from the government, or it can disqualify them from certain kind of benefits. So it's very important that you make sure those beneficiary designations are funneling those assets through the trust in that kind of a situation. Cryptocurrency, I should just mention, cryptocurrency currently doesn't really go anywhere by title. I mean, what I would say you should do is list it on your schedules. Definitely list on your schedules to demonstrate your intent. But what you really have to do is make sure that one way or another, your key, your password, your ability to access that crypto account is somewhere that your successor trustee is going to be able to get a hold of it. Because usually without whatever password or key that you have, it can be lost forever, and there's no real way to transfer title to crypto in most cases. So make sure it's included on your schedules, and make sure that whoever needs to have it will have the ability to access that account later. I already touched on automobiles. Do not, if the assignment of property into the trust will cover that, do not feel the need to transfer title with the DMV, because like I said, it can cause all sorts of unpleasant issues. Funding properly. So here's some simple steps to make sure that you get it right, that things are properly funded. One thing for all your sort of banking, checking, and any sort of investment accounts that are not specifically beneficiary designated like IRAs, review your account statements. When you get the account statement, hopefully what it says is your name, not as an individual, but your name and or your and your spouse's names as trustees of the trust. Sometimes it'll just have like a TR there as a shorthand, but try to make sure when you review those account statements, and for a lot of you for checking account, it should have that in the upper left-hand corner of your checking account instead of just your names as individuals. Often what it should have is your names as trustees of your trust. So review those account statements and try to make sure that your accounts are actually titled in the name of the trust. Home title reports. That's something that, if you schedule an appointment with, we can certainly do that as part of the appointment. Or if you have the ability, if you know a real estate agent, sometimes they'll be able to run title reports for you. And sometimes you might figure out how to do it yourself. But I think it's very important to, every so often run a home title report just to make sure that your house and or any of your, investment properties or vacation properties are still in the name of the trust. You will only know if you run a home title report, just in case something happens on title. Make sure your beneficiary designations are updated. As I mentioned that earlier, maybe every so often, every couple of years, you want to check in with the company that's managing whatever beneficiary designated account we're talking about. But every so often, try to check, whether you can do that through an online portal or whether you actually have to contact someone to review those beneficiary designations. Make sure that you do every so often just to make sure that everything's the way that you want it to be. Make sure that if you need to, that you retitle everything correctly. If your house or one of your other properties is not in the name of the trust, or if you have an account that's not in the name of the trust, you need to work with an attorney, and or if it's a bank account, work with the company in question to make sure that things get titled properly so that you can get out in front of it without leaving the asset out of the trust in case you pass away. If you're going to, a helpful document, again, as I mentioned earlier, the certificate of trust. Usually for us, that's going to be the first tab in your binder. If you've done an estate plan with us, will be the certificate of trust that tells the bank or whoever the company is that you have an account with everything they need to know to properly title that asset in the name of the trust, including, at least for us, it'll literally say in all bold at the bottom of page 1, usually exactly how to title it in your name as trustee of the trust so that they don't have to do any guesswork. I don't want to disparage bank managers, but let's just say we like to keep things as simple as possible for them. Updating schedules, always update your schedules. If a bank account changes, there's so many times where maybe your bank merges with another bank or another bank buys them out. There's also situations maybe where your account is subject to fraud and they have to basically give you a new account number and open a new account for you. Any changes like that, we want to make sure we update those schedules. And if you're a client of Cope & Barger's, please make sure that we usually give you the ability. If you've been with us recently, we would have given you a flash drive, and that flash drive will have editable copies of those schedules so that if you need to, you can update them yourself. If you do update them yourself, please get us a copy so that we have a backup copy. We always like to keep an updated digital backup of everything in your estate plan. So that was a lot. I know some of you may have questions. I haven't even, to be honest, looked in either the chat or the Q&A. But I promise you, now that we're getting towards the conclusion, I will take some time to review all those questions. So if you're screaming at your screen right now because I haven't been answering your questions, please bear with me. I will get to those. I just usually like to save those for the end, just so I can get through everything, because sometimes those questions get answered, and I think it's just more helpful not to break things up and to deal with them at the end. But how can we help? Obviously, you're gonna get a free appointment if you want to have a review, or if you've never done any estate planning with us before, an initial consultation. We're going to give you a free appointment for attending this webinar. So we'll want you, especially if you're a client of ours, or even if you're not, review your estate plan if you have one at least every 3 to 5 years. If any major life situations come up, like especially marriage or divorce is a great example, come see us. Oftentimes, if you've sold or purchased any real property, it might be a good excuse to come see us to make sure that everything's set up the way that you want it to be. If you've received an inheritance, that's another good time to have a conversation with us. Inheritances, I should note, are always separate property, at least initially when you inherit them, but obviously they can be commingled very quickly. So it's worth having a plan for what you want to do with that inheritance. And then obviously, if you suffered the loss of anybody, or if, you know, on the positive side, if you've had any new births, that might change what you want to do with certain kinds of beneficiary designations or certain kinds of decision makers. Or if it's your first child, it may add a whole new dimension to your estate planning, such that you want to make sure that we have a nomination of guardian built into your will. So these are all reasons to come see us. So please, if any of those things are applicable, come see us so that we can review your estate planning or plan it out for the first time with you. Why Copenbarger? You know, obviously, I have positive things to say about the firm that I work for, but even if I didn't work for it, it's, you know, not, it's been around since 1979, so it's been around for several years. And as you can see, hopefully by my age, that the plan, there's multiple other attorneys across the firm. If you recall the slide with all our pictures on it that are about my age. So the plan is to have it be around not just for, you know, the first generation, but to be around for generations to come. We have 10 full-time attorneys, one attorney counsel. We have CPAs. We have over 350 years of combined experience. Multiple attorneys have advanced tax degrees. If you see LLM after any of their names, that's a clue to that'll clue you into that. We have multiple certified specialists in probate, estate planning, and trust law. Several over 45 highly qualified support and staff members, and we have multiple locations and a diverse staff that's all set up to meet your needs and help you wherever you happen to be and to be where you need us to be. So please contact us. I'm going to leave this information up while I start going through everybody's questions. All our contact information is set up there, whether you want to go to our website, email us. Please also, I do want to make sure that you know, over on the right, there's a digital evaluation link. Please, 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 before you go today, I would really appreciate it if you would click on that link and fill it out so that we can get your feedback. We really value your feedback, and we will tailor what we do in the future to that feedback. So we want to know if what we're doing is helpful, because we only do this to serve our clients and to serve other people. So we want to make sure that it's actually helpful. So please, 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 before you go, fill that out. I will now start looking at, I will first look at the Q&A, and then if there's anything in the chat, I will look at that as well. So bear with me. First, I have a question. If an aging relative is planning on giving a financial account like a brokerage account, should the beneficiary be our trust, or should that be put in the trust after it has been inherited? So the first thing to note is it cannot be in the trust. Well, let me see. An aging relative is planning on giving a financial account. Should the beneficiary be? So when you're saying, so you're talking, it seems like what you're talking about is not how to interact, how the person who's holding that account is going to have it interact with their trust, but you're talking about you as the beneficiary. To what extent should that have to do with your trust? That's a little more complicated than the typical situation. So if I'm understanding that correctly, I would say that it can be transferred to your trust after you've already inherited. One thing you want to watch out for is the Secure Act has changed typically the time period that you have in order to transfer all the assets out of that account. If it's like a deferred compensation account, usually you have to get everything out of it within 10 years. I would say typically that what they should do is have you individually just be listed as the beneficiary, not your trust, and then have you handle transferring that asset to your trust. Usually what the way I would transfer is to take the money out of that account and put it in something else in the name of your trust. But there could be that's worth a conversation. I would say that my typical advice would be to just have, that relative list you guys individually as beneficiaries, and then work out transferring that asset into your trust one way or another after the fact. But that could be a longer conversation that would probably be a good idea to have an appointment, because your situation might be unique and I don't want to miss anything. Next question, if a real property is listed in the trust, however, the title is not changed with the added word trust, will it be transferable to the beneficiary? So it's really a binary thing. It's a yes or no if something's held in the trust, and it's real easy for at least me and other attorneys to tell if it's in the trust. So if by listed in the trust you mean it's in the schedules, in the schedules doesn't mean that the property is held in the trust. The title has to be held in the trust. We're talking about real property with the recorder's office in order for it to actually be held in the trust. So that title needs to be something akin to you as trustee of your trust, or you and your spouse as trustees of your trust. That needs to be the way legal title is held, or that property is in fact not in the trust. If it's in your schedules, that can at least provide us with an argument to try to do a petition to ask the court to declare it as a trust asset after you pass away. And it's a little bit easier and quicker than having to go through a full probate scenario, but it's still going to cost your beneficiaries thousands of dollars and some court time. So make sure that it's actually titled. Run a title report if you have to, and make sure that it's titled in the name of the trust, because it's not going to be in the trust without a further court order if it's just listed in the schedules and its title is not in the name of the trust. Next question. If one puts 0 assets into a trust, but they have a pour-over will, can homes be moved into the trust after they have died? That's typically what a pour-over will is there to do. A pour-over will does require a full probate. So just to be clear, what a pour-over will does is it basically just acts as a contingency plan in case something goes wrong with having assets in the name of your trust. And the pour-over will just says, it has to go through probate, but what it says is everything just goes back into the trust. So your executor, named in your pour-over will, can go through a whole probate and make sure everything ultimately gets transferred. It's going to cost time and money, gets transferred in the name of your trust. But the one concern there is when you say 0 assets into a trust. As I touched on before, there is a substantial risk that if you did not fund your trust with any assets at its creation, that a judge might later say it's not a valid trust. Now, I think sometimes that's just kind of an overlooked formality, but I would always be very careful about that. If you have a trust, when you create the trust, make sure you're funding it with something. Make sure there's a bank account or something that you're actually funding the trust with, because we want to make sure that that trust is valid. So that said, a pour-over will can allow your executor to transfer your assets into the trust after you die, but you really don't want to do that because it's going to require a full probate of the procedure for that pour-over will. The next question, how do we know if the trust was funded at inception? We did it with my company, with James. So I would say as long as there's assets listed on your schedules, as long as your schedules aren't blank, then you've at least made the good faith effort to fund your trust at its inception. I mean, we really wouldn't let you get away with that. The one complication I can say is we can have set you up for success by listing those, by demonstrating your intent to fund the trust with those assets. But you are going to want to make sure that, for bank accounts and checking, normal checking and savings accounts, those kinds of assets, that you actually did the follow through after the appointment and actually retitled those assets in the name of the trust as well. So as long as you did that, then your trust was funded. And certainly if we do a deed for you at the appointment, usually if you're creating a trust with us for the first time and you have real property, you have a home and or investment properties, we will do the deeds, sign them at the appointment. If that happened for you, slam dunk that your trust was funded at its creation. You don't need to worry about that. You may need to worry about what happens to title after the trust in case you refinance and take the house out of the trust. But at its inception, if you saw us do a deed with you, you don't need to worry about it. It's a slam dunk that we funded the trust. Bank accounts or anything like that that have a beneficiary listed don't need to be in the trust. So it depends what you mean by need. You don't have to fund your trust with any particular asset. If you have some sort of reason, you can just keep whatever you want out of the trust. But if you want the rules of the trust to apply to any of those assets, then you're going to want to make sure they're in the name of the trust. Certain kinds of assets, just to try to reiterate, if they're beneficiary designated accounts like IRAs, 401ks, life insurance, HSAs, FSAs, and certain kinds of annuities, all those kinds of beneficiary designated accounts, we wouldn't title in the name of the trust. But then that's a further consideration as to whether or not you want to fund the trust through beneficiary designations by listing the trust as a beneficiary on those accounts. And that's going to be whether or not you're going to want to do that is somewhat situation specific. So that's a good reason to have a conversation with an attorney about that. should certificates of deposit with assigned beneficiary be placed in the trust? Typically, I mean, again, those are different kinds of beneficiary designated accounts. Usually you're not going to be able to really title those in the name of the trust. But you may want to list the trust as a beneficiary or at least a backup beneficiary. Sometimes you're going to want to, as with all other beneficiary designated accounts, list maybe your spouse, if you have one, as the first beneficiary and the trust as a backup. But it can be a good idea to have the trust listed on a CD. It's just whether or not, to what extent I'm going to advise you about that, like to what extent I'm going to kind of twist your arm and really tell you to title it in the name or to have the beneficiary designation set up with the trust as a beneficiary, is going to depend a little bit on your specific situation. But it's going to be a slam dunk if you have a special needs trust or those lifetime protective trusts. You know, we also call them generation skipping trust provisions in your trust. Then definitely I will encourage you to have anything beneficiary designated listing the trust as a beneficiary. So someone's asking, my tax sheltered annuity has the primary beneficiary as his wife, and it instructs the beneficiary to date it when the time comes for transfer. So wait, sorry, I had it shift up. So tax sheltered annuity is a primary beneficiary is his wife, and the contingent beneficiary is the trust. Is that set up correctly? Yeah, that's typically how I would advise you to set it up. You know, obviously, maybe there's some sort of super complicated thing that, you know, I might want to know before giving you something that I would 100% call legal advice versus the educational purposes and spirit of this talk. But typically, that's going to be the way I would advise you to set up. If you want to set up the trust as a beneficiary and you're married, I will typically advise you to have your spouse listed as the first beneficiary and the trust as the backup beneficiary. For an auto transfer, can the truster pre-sign the pink slip title and instruct the beneficiary to date it when the time comes for the transfer? I'm not sure I know the answer to that question in terms, that's more of a DMV specific question rather than a question that has to do with estate planning or the concerns that I have for today. Just let me read it one more time, think about it. I don't know for sure if they can do that or not. What I would say is if we're worried about how someone is going to inherit your car through your trust, I would say not to really worry about that kind of a procedure. Or, you know, if it is a good idea or isn't a good idea, I can't 100% opine on it, but you don't necessarily have to worry about the specifics of that. All I would say is if you have an assignment of property into your trust that we've prepared or that someone else prepared that says all your tangible personal property is property of the trust, then that will control regardless of how title is held with the DMV. And if your trust provides for that tangible personal property to go to your beneficiaries, then they can just take that assignment and the trust if they need to the DMV. But usually the DMV doesn't necessarily even require that level of scrutiny. Usually it's pretty easy to transfer to a child, but that probably is not necessary. Is your slide deck available for review after your presentation? I know that we're going to put this video up on YouTube afterwards. I'm not 100% sure if the slide deck itself is available for view other than by watching that video, but that might be something to just go ahead and, you know, if you shoot us an email or give us a call, we will probably be able to answer that question. Why should we go to Copenbarg instead of doing a trust online? That is a great general question. Very great question. Why should we go to Copenbarger instead of doing a trust online? I assume by trust online, you mean going through somebody like LegalZoom. I have a lot of opinions about this. So the most important reason to go to an actual attorney rather than using something like LegalZoom, or sometimes there's non-attorney services that are staffed by, say, paralegals that can do it for you. One of the main reasons is that if something goes drastically wrong with your estate planning, the person on the hook if you use LegalZoom is you. LegalZoom is not giving you legal advice, and therefore they are not accountable if you do something that ends up running completely contrary to your intentions for your estate planning. They're not accountable. You can't sue LegalZoom. They're not an attorney. They can't commit malpractice. Not that I ever would commit malpractice, but I am accountable. So if something goes wrong, and not only that, I can, unlike LegalZoom, I'm not just a form that you fill out that'll spit out whatever it spits out. I can sit down with you and review your specifics and explain to you the costs, benefits, the good and the bad of any individual decision that you might make, and make sure you actually understand what you're doing. Because the chances are, unless you know what I know, if you try to do a trust with LegalZoom, you're not going to have a very good idea of what you're actually doing and what the potential consequences are of doing it wrong. And I've had situations, the worst case I ever tried in my life was a case where the whole estate plan was ultimately held to be invalid. It was prepared by a financial planner rather than an attorney. And the intent of the estate plan was completely controverted by holding it to be invalid. And it went to two daughters that this person in question had fully disinherited in favor of his grandchildren that he had to raise, because Child Protective Services took all his grandchildren away from those two daughters. And because the trust wasn't properly prepared and executed and all the documents weren't set up properly, his grandchildren got nothing and those two daughters got everything. And there is no ability to sue that financial planner for malpractice after the fact. So I would very strongly urge you to go, whether it's Cope and Barger. I obviously think we're very good at what we do, but even if it's another attorney, please go to an attorney and don't do it on LegalZoom. Sorry for that. Obviously, I have a lot of passion and thoughts about that. Prop 19 transfer of basis. Mom buys a new home and transfers the basis of the old home. How is this done inside or outside of the living trust? And the new property needs to be transferred back into the trust. Do we need to come to see you to do this? So technically speaking, whether or not it's qualifies for Prop 19 isn't a question of the trust specifically. Whether the transfer qualifies is simply a matter of whether the parent was living in the property as their primary residence for 2 years before the transfer, and whether the child taking it is taking it as their primary residence. So basically what you need to do to ensure if those two things are true is when you do the transfer, when you do the grant deed, you're also going to want to submit the preliminary change of ownership to the assessor's office, and you're going to want to check the right box that says it qualifies for that exemption. If you don't submit the paperwork correctly to the assessor's office, they won't give you that exemption, and you have to do it within the relevant time frame. So I would say it's a good idea, because if you go through us, we'll handle that for you and make sure it doesn't get screwed up. To what extent the trust has something to do with that, usually that's going to have to do with, I talked about a right of first refusal can help preserve a child's opportunity to take the property as part of their inheritance rather than forcing the property to be sold or something like that, if they want to potentially use it as their primary residence. So that's something to discuss with an attorney, whether or not that's a good idea. If there are two living trusts with the same assets in each, which governs? Maybe one trust was set up in California and one was set up in Washington. Clearly a conflict, but if they forgot or didn't know about the prior trust, or just set up two trusts, what happens? Well, a trust, as I said, only governs what's in the trust, and what's going to control is the title designation, because those trusts, the trust essentially can't have the same assets in each. The trust can purport to have the same assets in each. Maybe each trust lists all the same assets in their schedules, but assets are going to follow a title designation, and those trusts are going to have different names one way or another. And so what I would do to see what trust the asset is actually in is I'm going to review the title designation. I'm going to review how title's held with real property by doing a title report, or I'm going to go to a bank or financial institution to determine how a financial asset's held. Because one way or another, it'll be in the trustee's name as trustee of that trust. And one way or another, that trust is going to have a different name, even if we have to go so fine-grained as to look at the date the trust was created. If someone was silly enough to set up a trust with the same name, at the very least, it's not going to have the same date of execution. So that's what we would have to do. The schedule of assigned assets are not automatically considered part of the trust unless the title on each item has been applied to them. It's just a sort of accounting list to make sure our assets are considered. Kind of, yeah. So the schedule of assets, the first purpose of it is just informative for your successor trustee. They can know right away, oh, these are the assets that I'm supposed to take account of, and sort of, figuring everything out and making distributions. But the second thing, as I mentioned, is the schedules can demonstrate your intent, which is a relevant element. So obviously, if you pass away and assets are not titled in the name of the trust, One thing I might have to do is use the pour over will, which is going to require me to go through a full probate proceeding. The end of that probate proceeding will result in me using the pour over will to transfer the assets into your trust so that they can be distributed in accordance with your trust. But I have to go through a full probate proceeding, which can easily take like a year and a half and cost, all the associated costs that a probate case has with it. I can potentially, if it's listed on your schedules, try to avoid having to go through a full probate and basically get it sussed out in one hearing, because I can try to make an argument based off of case law. The case is called Hegstead. I can file what we refer to as a Hegstead petition and say, look, they listed in their schedules, clearly their intent was for it to be in the trust. Judge, please just call it trust property so we don't have to go through probate. Now, that's still not ideal because preparing that petition and going to court is going to cost, a few $1,000s at least and require at least one hearing, if not more. But it would likely be a whole lot simpler, shorter, and cheaper than going through a full probate. So that's one of the benefits of demonstrating your intent as regards to what assets you mean to be in your trust on those schedules. I think this will probably be, thank you for everybody that's still bearing with me. This may be my last question. I will check the chat as well, but this may be my last question for today. Is it safe for a boat asset to be held by a separate LLC and the LLC to be held in the trust? Yes. If we've assigned that LLC into the trust and you've made sure that that LLC is properly owned by the trust, then all the assets held in that LLC will, by virtue of being owned by the LLC held in the trust, ultimately be trust property. So I don't know for sure what it means to buy, is it safe? But if what you're asking is that boat going to be able to be distributed and have the rules pursuant to the rules of the trust and have the rules of the trust apply to it? Yes, so long as it's owned by the LLC and so long as the LLC is in the trust, then by the transitive property, basically the boat's in the trust. So I will just check the chat real quick to make sure. Let's see so maybe one more question. Says, if I'm the trustee to an uncle's trust for any foreign real estate, should I put those properties in my family trust for any reason? The problem is that your trust, or the only issue with that is your trust, depending on what kind of foreign real estate, your trust probably is not necessarily going to be, I won't say even probably, it's not necessarily going to be legally recognized in that other country. So you can always list the assets on your schedules if you want, but it may be the case that that trust is not going to apply, because a trust is essentially a contract you create with yourself. And based on the full faith and credit clause of the Constitution, all 50 states are going to recognize that contract equally, no matter where you created that contract, no matter where you created that trust. But we don't necessarily have the same full faith and credit for contracts when we go to a different country, because they're not subject to the Constitution, the laws of the United States. We may, by treaty, depending on what country it is, have a treaty which dictates that we're going to honor each other's estate planning documents. But most countries aren't going to have that, and that's going to be a case-by-case basis. So that's another one of those circumstances where I would say probably you might want to talk to an attorney about that. And so with that, I am probably going to conclude for the day. I believe I've answered everybody's questions. Please, if you haven't already, if you're still with us, please fill out that digital evaluation by clicking on that link on the far right. And I just really appreciate everybody's time. It was a pleasure. Hopefully this was helpful. Like I said, please give us your feedback so I know for sure if it was helpful. Thank you so much, everybody.